Hey guys, it's Navdeep Singh Jadla. Thank you for clicking this thumbnail. Today we're going to talk about an open work permit application. In this application, a fresh marriage has taken place. So we'll see what happened and what went wrong, and we'll see what circumstances were there. The applicant name is Mr. Bhupinder Singh Maan, as you can see right here. This case concerns the decision of a visa officer in New Delhi, India, to refuse the applicant's application for work permit as the accompanying spouse of an Indian national who is in Canada on a study permit. Under the Immigration and Refugee Protection Act, spouses of certain temporary residents are eligible to apply for work permit, in this case open work permit, as we already know. By letter dated February 5th, 2019, the officer refused the work permit application on the basis that the applicant had failed to provide sufficient evidence or explanation to support his claim that the material relationship of his spouse is genuine and is not entered into primarily for the purpose of acquiring a status or privilege under IRPA. The officer found the applicant inadmissible to Canada pursuant to Section 40, which carries a 5-year ban to re-entry to Canada under Section 42 of IRPA. So the applicant submits that the officer's decision is unreasonable. An officer made findings of the fact in a perverse and or capricious manner. And the fourth point, the federal judge says, for the reasons that follow, I am of the view that the officer's decision is reasonable within the law and this application for judicial review is dismissed. Mr. Bhupinder Singh Maan, the applicant, is 25-year-old national of India. The applicant is recently married to Ms. Pavanpreet Kaur, a 23-year-old national of India who is currently in Canada on a study permit. The applicant and Ms. Kaur are both residents of Punjab through family connections. They were set up to be in an arranged marriage. The families met on January 31st, 2018, which was around the same time that Ms. Kaur submitted her application for a study permit in Canada. Ms. Kaur had drafted her application on January the 29th, 2018 and submitted it to Immigration Consultant, who filed it on January 31st, 2018. So practically the applicant gave all the documents to Immigration Consultant on 29th of January, and after 2 days, exactly on the same date, the Immigration Consultant submitted the application when both of the families were meeting together to discuss about the marriage. The arranged marriage proceeded quickly after families met, as the applicant was the eldest of 2 sons and his family was keen on an early marriage for their son. After discussing about the marriage on 31st of January, on the very next date, on February the 1st, 2018, a small engagement ceremony was held. The marriage took place exactly after 4 days on February the 4th, 2018, with religious ceremonies and large gathering of friends and family. After the wedding, the couple visited various relatives. Ms. Kaur states in her affidavit that she was with the applicant's family for over 2 months prior to her departure. Ms. Kaur received her visa on March the 15th, exactly after 6 weeks from the submission, and she left for Canada on April the 13th, 2018, almost after spending almost over 2 months of time with the in-laws family. And Ms. Kaur alleges that upon the landing, she informed the immigration officer at the airport about her change in marital status. On or about June 29th, 2018, the applicant submitted his work permit application as an accompanying spouse to Canadian visa officer in New Delhi, India. The applicant was invited for an interview, and on November the 15th, the interview was conducted in New Delhi. So after almost 5 months, the applicant, Mr. Bhupinder Singh Maan, submitted the visa application for open work permit. So after over 4 months in processing, the interview happened in November 15th, 2018 in Delhi. So the pre-interview entries on Global Case Management System GCMS notes indicate that the Ms. Kaur had been single when she applied for her student permit and married shortly before her visa was issued. Ms. Kaur arrived in Canada soon after the wedding but did not inform the visa office or the immigration officer at the port of entry that her marital status had changed. During the interview, the officer noted several concerns regarding the bona fides of the marriage between the applicant and Ms. Kaur, such as incompatibility of education, the inability of the applicant to explain how the wedding could have been arranged in 3-4 days, the applicant's lack of knowledge on the fact that Ms. Kaur had been planning to go to Canada, the fact that the photographs did not show the stated attendance of 250-300 guests at the wedding, which they normally expect, the applicant's lack of holiday with Ms. Kaur, and the applicant's inability to provide an explanation when questioned. So the applicant's lack of knowledge of Ms. Kaur and limited evidence of contact between applicant and Ms. Kaur. By the letter dated February the 5th, the visa officer refused the work permit application based on the application, supporting documents, application notes, interview notes, the officer found that the applicant provided insufficient information or explanation regarding the progression of his relationship with Ms. Kaur, the wedding, the time spent together after marriage, their current living arrangements to support the assertion that the marriage is genuine. So the officer also found that the applicant provided insufficient evidence or explanations as to the ongoing communication between the couple before and after the marriage. So by now you already have a fair idea about the factors which plays an imperative role in the assessment of the visa application. So basically they're concerned about 4 factors. One is development of the relationship and the circumstances in which the marriage have taken place, whether the marriage took place as per religious rituals, who was there, how the meeting was arranged, the incompatibility or compatibility factors, how the families do fit with each other. Third, the time spent after the marriage, that's we call cohabitation. And fourth is, what is the current status, what is happening right now, what sort of relation they both are having, how are they ensuring that they're communicating to each other like a couple. Majority of the applicants would agree to me that the interview is the most distressing and frustrating part, and nobody wants to attend the interview. I believe the interview can be avoided if your immigration consultant can assess your application comprehensively and predict what sort of questions may arise in the visa officer's mind after looking at the profile, and can provide proactive answers already in the application. This is the best way to avoid the interview, because the visa officers are not our enemies, so they need answers for all sort of questions which may come to their mind as per the case, as per the circumstances. And if the honest immigration consultant can provide proactive explanations already, I can assure you that there won't be any interview happening. Thus, on the balance of probabilities, the officer found that the applicant failed to provide sufficient evidence or explanations that his marital relationship to the spouse is genuine or not entered primarily for the purpose of acquiring a status or privilege under the IFPA. So the officer also found that the applicant is inadmissible for the period of 5 years. Now this might have happened because visa officer was not satisfied with the intentions and with the answers in the interview, and he believed that some of the answers are in contrast to what was declared on the application. This could be the highly likely possibility. So here is the analysis. If you would like to read it, you can just stop the video and read it line by line. Conclusion is, the officer reasonably found the applicant to be inadmissible for misrepresentation under section 41A for the period of 5 years, and also the judicial review was dismissed. Thanks for watching this video. If any of your relatives, friends will be applying for open work permit application or are already in the process of submitting the application, you would like to share this video with them, because I think we learned a lot about what visa officers are looking for, and this video might help them so that they can also submit the application perfectly. Thank you so much once again. I'll see you in the next video.